Landlords, we have a decision from a housing court in a non-payment eviction case that will blow your mind away. It will leave you dumbfounded, stunned, flabbergasted. You will not believe this decision from the court. And that decision is... This is the Landlord Advocates, where we help landlords become better landlords. I'm your host, Matthew Lyman. Welcome. In New York State, there's an eviction moratorium in place until the middle of January 2022. With this eviction moratorium comes a declaration of hardship. One side is financial, the other side is medical reasons as to why you cannot pay your rent and why you cannot be evicted. Our team has had many cases heard during COVID and many before COVID. Well, we had a few in the early part of September, and the cases were heard by the courts, and the decisions of the court blew us away, to the point where we ordered transcripts in these cases to appeal the cases and the decisions and to share this information with you, and this is the decision here now. In this particular case, the tenant came to court, and it signed the declaration of hardship claiming health-related reasons as to why he cannot pay the rent and why he cannot move. Our team immediately handed him a limited judicial subpoena ducis tecum for him to provide medical records to substantiate his self-certification of this declaration to say, yes, I cannot pay and yes, I cannot move for this health-related reason. We served a subpoena on him. The case was then heard late September 2021. We're going to be reading you excerpts of this decision. And mind you, it's going to blow your mind away. We're not going to read the whole thing, only excerpts. It begins. From the court, what proof do you have that the respondent is not experiencing a health-related hardship? Our team, Your Honor, you understand that with self-certification, I certainly cannot know all of the respondent's health care problems. We are not entitled to that information pursuant to HIPAA, which is the Health Insurance Portability Accountability Act of 1996. This basically ties up medical records from those who have those records, and the only way that you can acquire them is through a court order, or the tenant, in this case the tenant voluntarily brings that information to court. But even with a subpoena on medical providers, that will not work unless there is permission given by the person with whom the medical records are being sought. However, the respondent has placed, by checking that box, his condition of a health situation squarely within the premises and procedures of this court. He has made it an issue of this action now. And what that means, landlords, is that when you go to civil court and you bring forth an argument to defend yourself regarding an allegation, and you do that, now you open up the floodgates to the other side to refute your claims. So this individual claiming a health-related issue should have the protections of HIPAA in regards to that narrow issue that he has removed to substantiate his claim of signing the declaration of hardship due to health-related reasons. I was granted a hearing. He was supposed to bring information. The information is not here. He seems able-bodied enough based upon the observations that were made in open court, the judge. Well, unfortunately, none of us can make a decision about a person's health based upon the way they look. What? You absolutely can. You can determine that a person who is morbidly obese is not going to be running the New York City or Boston Marathon. You can ascertain that somebody who is blind, Andrea Bocelli, Stevie Wonder, will never drive a car. You can ascertain that I, your host, was born with a speech impediment. It's clearly obvious that those three descriptions of people who have disabilities or health-related issues is clearly obvious to the person viewing that individual. That's just not a valid conclusion to make. Yes, it is. I understand you did serve a subpoena and the individual did not complete the subpoena. However, I'm not going to hold anybody in contempt for failure to submit to your subpoena. Our team. On what basis, Your Honor? I would like a record made on this particular thing because this is going to go forward not on a single case, not on dozens of cases, potentially on hundreds of cases. That's just us. That's not you, who might be in New York City, Binghamton, Syracuse, Rochester, Albany, Saratoga. That's just us. I want to be crystal clear that this court will not hold anybody in contempt for non-compliance with a subpoena served by an officer of this court before this tribunal. With this court, this is the court. With this court, meaning this particular judge, is not going to be issuing any contempt for failure of a respondent to submit to your subpoena that you served on, I forget the date, she goes on. I'm not going to hold that individual in contempt. I believe that you have failed to establish that the respondent is not experienced in a hardship. You put forth no credible evidence that would indicate that this individual is not experiencing a hardship due to a significant health risk due to COVID-19. Therefore, I'm going, and the burden is on you as the landlord, as the attorney for the landlord, to present to the court whatever evidence you have that would be sufficient enough to challenge the hardship declaration based upon the health risk. Evidence. We submitted a subpoena to the tenant to provide us with information to corroborate their claim of a health-related issue. Under HIPAA, we cannot get that information. And even if HIPAA did not exist, and we had wanted to send out subpoena ducis tecum to healthcare providers that this tenant may have, how the hell are we supposed to know? How the hell are we supposed to know who they are? Are we supposed to subpoena every doctor, every hospital, every urgent care facility, every drug treatment facility, every mental health facility? Every? This could account for the landlord spending tens of thousands, if not hundreds of thousands of dollars to try to ascertain this information from healthcare providers, as they do not know the healthcare providers that this tenant has, or your tenant has. So for that reason, I'm going to leave the hardship declaration in place and adjourn this matter until January, after January 15th, 2022. Our team. Your Honor, by failing to respond to subpoenas issued by an officer of this court, the respondent has spoliated. We'll explain that in a minute. Pursuant to the civil procedure laws and rules, they should strike the defense, okay? He no longer would have that defense. Because the court is not going to require respondents to respond, and the court is not going to require respondents to address their contempt of a judicial proceeding, then the court is allowing the spoliation of evidence. Now, what that means, spoliation of evidence, my friends, is that when you go to courts and the other side makes an allegation, in this case, that they're suffering a health-related issue, the spoliation of evidence, what you want is the evidence to prove that they are not, or for them to produce the evidence to corroborate their claim and to withhold and to uphold their claim, to prove it. When the court does what they call spoliation of evidence, is that it is allowing the suppression, possibly the destruction, the withholding of that evidence. Spoliation of evidence is when the other party decides not to bring forward the evidence that is being sought, because it is to be presumed that the evidence being withheld is detrimental to that individual. The court then must rule in favor of the other party, because the party with which the information, the evidence is being sought, refused to provide it. In this case here, because the court is not allowing the subpoena to be issued, they're not holding the person in contempt. They're putting the burden of possession, the evidence, squarely on the shoulders of the landlord, with information that they basically cannot acquire. They are allowing the spoliation of evidence to the detriment of the landlord and to due process. By the respondent not providing that information, our right to due process granted under the United States Supreme Court ruling has been run over by this court. And ladies and gentlemen, it has been run over. And not by a tricycle, not by a bicycle, not by a unicycle. It has been run over by a convoy of tractor trailers. It may never come back to light, ever. Essentially what you're saying is by respondents intentionally not answering the subpoenas, which is contemptible, they can automatically win all such matters. And as such, our due process rights have been defeated. The court goes on to say, this is not a case about winning. What? What? Judge, are you serious? This is absolutely a case about winning. It is about the landlords winning back possession of their property, winning the judgment for the money that the tenants owe. But most importantly, the landlords want their property back. So it is a matter of winning for the landlords. And by you and this court deciding that we cannot use this subpoena, the tenant does not have to provide this information, therefore, you are automatically siding with the tenant and defeating the entire due process, which has been afforded to them under the U.S. Constitution and by a ruling of the U.S. Supreme Court. Again, she goes on to state that the evidence, the burden of evidence is upon the petitioner or landlord and not the respondent tenant. That is incorrect. And what you have articulated today does not meet the court's belief that it is sufficient proof that you have put forth in court. And based upon that reason, I believe you have failed to sufficiently provide any evidence about why you are challenging the hardship declaration. And therefore, I'm going to let the hardship declaration stand. So this time, I am going to adjourn your matter until it's the end of January. By the time this is adjourned down for a conference and all of that, and by the time the landlord might possibly win this case, that tenant will be there until St. Patrick's Day 2022 or even later. Our side, our team, I would like the court to note my objection with the ruling. Okay. I'm going to ask for a copy of this transcript to be generated. I'm going to have to appeal it because it does not affect just only the proceedings here with this particular petitioner, but the next 100 cases that I put forth before this court, including ones coming on in the next hour and tomorrow and so on. Our team. A single ruling on this court is going to defeat hundreds of potential claims. Not only in our court, but possibly in your court. In your court where you are looking to evict your tenant. And I just like to put that at the foot of this court, realizing that this decision goes far. It's far more reaching than the court may realize at this point. And they're right, they may not realize it, but they're going to. And they're going to do that because of our team and our friends on our social media are going to be addressing this. Now, landlords, there is one pivotal aspect of this case that I will tell you right now. If you're drinking anything, eating anything right now, put it down, swallow, stop. A major point in this case is that the second appearance for the tenant to appear with the evidence and to come to court, the latter part of September 2021, did not happen. We've already told you that the tenant did not provide the medical records to corroborate their claim of signing the declaration. But it goes one step further. Are you ready for this, landlords? Are you ready? Are you ready? The tenant did not even come to court! The tenant was not even there! And the court ruled in his favor to have the case hung up to the end of January! How ridiculous, how stupid, how foolish, how wrong is that? It's very wrong. He didn't even come to court. He did not even call the court. He did not send a text. He sent no messages to the court whatsoever. He never showed up to court at all. We should have won that case right then and right there on a default for him not showing up, but the court did not even do that. Very, very wrong. Unbelievable. Landlords, we are going to explain other cases that we've had, but we're not going to do it in this whole video here because it'll go on for quite a while. We ask that you subscribe to our channel. We ask that you hit the like button, leave comments below. What do you think about this? Is this right? Is this wrong? Obviously, you better say it's wrong because it is. Hit the notification bell because we're going to be producing a lot more videos as time goes on. Because this is getting more and more aggravating, not only to us as the landlord advocates, but to each and every one of you out there in America. Because this is happening in New York, it can happen in California, it can happen in Massachusetts, it can happen in Washington State, it can happen anywhere. Landlords, until then, take care.